Did you know that you sometimes cannot simply rely on the provisions of a contract, of a written agreement? The agreement may set out the rights and obligations of the parties and may make it fairly clear what you're entitled to do or not do. The challenge is you cannot act on contractual rights in a manner that is not in keeping with the duty of honest performance. That has been made clear most recently in the Supreme Court of Canada in the decision of Callow and Zollinger. In that particular situation, back in early 2013, Baycrest had a winter maintenance agreement with a gentleman named Mr. Callow. Under the contract, Baycrest had a right to terminate the agreement on 10 days written notice. It was that straightforward, that simple. The challenge was that Baycrest over the spring and summer of 2013 had led Mr. Callow to believe that they weren't going to rely on that provision, that in fact they were going to renew the contract with him. As things unfolded, come closer to the fall of 2013, Baycrest simply invoked the 10-day termination notice period. The Supreme Court of Canada said they could not do so, that was a breach of contract. Why was it a breach of contract? It was a breach because they had acted dishonestly in misrepresenting to Mr. Callow what their intention was with respect to that 10-day notice provision. They essentially led him to believe they would not trigger it when they ultimately ended up doing so. You cannot mislead somebody, you cannot misrepresent to somebody that you're not going to rely on a contractual right and then attempt to do so in circumstances where they're otherwise prejudiced. And you can't do it not simply by saying things which are misleading, but also you can't mislead them by half-truths or omissions or the failure to clear up misapprehensions where it would be appropriate to do so. When you intend to exercise your contractual rights, make sure you do so consistently with the duty of honest performance. I'm Dan Chitiz, and I'm a commercial litigator with CPLLP.